Hello, I am P. R. Krishnan. Welcome to my presentation episode number 5 on inheritance law. In the last 4 video we have covered from basic to the terms why will, what is will, what if will is not made or not registered or not probated and the consequence thereof, how you go about preparing the will, etc. In this video we shall look at registration process, the possibility of changes, revoking, cancellation of the will, the probate process and the duties of the executor. Registration. It is important to know some facts about registration. The registration process is quite simple. It is only time consuming. You need to take 2 witnesses along with you to execute. You don't need the beneficiary or the executor. However, as is seen, the beneficiary generally accompanies in normal circumstances. But 3 of you, that is you and 2 witnesses, must go and sign in front of the registrar, as we have discussed in earlier videos. Registrar will satisfy himself by asking questions like if you have made this will out of your free mind or was there any pressure, etc. He will ascertain if you are under the influence of alcohol or medication or pressure, anything, and if he finds everything is free, then he will okay it. If there are years, he might some questions may be directed to them also. Only after satisfying he will register and sign. So you can see, while registration is not compulsory, it is in your own interest to register it. Now it does not cost much also. Registration has its own importance and statutorily recognized. Tomorrow, for some reasons, if the will is lost, you can always get a copy. You can call for a copy from the registrar. Due to the above reasons, it gives a credibility or legal status to the will, and in case of any dispute, this stands in good stead. If you register it, another advantage is it cannot be tampered with. Money is anyone's weakness. We have seen history, and even now brothers kill brother or siblings fight tooth and nail for wealth created by parents, and in these hard times it is visible all the more, whether Ambani brothers or Munjal brothers or Malvinder and Shivendra Singh. Ideally we should register the will, and that will bring curtains to the infighting between siblings, and since it was your wish, so ideally register it. Often people ask, within how many days should I register the will? The answer is there is no time limit. You can make a will today, keep it or register it today, keep it for 1 year, and if there are changes you can keep changing it and keep it for another 1, 2, 3 or 4 or more years also before registering. So there is no time limit. But the benefit of registration will be lost if there is a dispute after your demise and you have not registered it. Once registered, it is less likely to be questioned by anyone. Place of registration. The place of registration will be the sub-registrar's office, where the testator usually resides. Now if you have 2-3 places of residence, the will contain all these places, but the registration of the will shall be done in the place where the testator resides generally. Where do you keep the will? You can keep the will safely with the executor. You can intimate the beneficiary, or you can keep it with yourself, or you can put it in a sealed cover and give it to your relative or close dependable friend, or you can also keep it with the registrar. It has to be put in a sealed cover with testator and executor's name along with their Aadhaar card details. For this, the registrar charges a nominal charge. That's it. At registrar's office, you need to go with 2 witnesses, as I mentioned, who should sign in front of the registrar. They charge 100 for registration and understand some 200 rupees per page for scanning. You need to stand in line, get it vetted by the clerk first, and then take it to the registrar for his signature. For registration there are some expenses involved which you need to pay. Questions have been asked whether one can make a will after death of the testator, register the will after death of the testator. The answer is yes. Exceptionally you can make. You have to convince the registrar saying the testator died but he was wanting to register it, but circumstances prevented it or whatever, and every document you need to show it. In such an event, if he is satisfied, then he might change or register. He might register. Let's move on to the next slide. Changes, modification and revocation. Let us look at how to change or modify or revoke a will, whether registered or not. First, you must be clear that you can make any number of changes to your will, any number of times during your lifetime. So don't be under the impression once you make the will you cannot change. The only condition is that if the original will is registered, this new will too must be registered. So what do you do if you register one will and there are many changes? Now, and also at a later date. Ideally you must register the original will, then keep adding or changing through the codicil route, which is basically addition of additional papers. Additions need not be registered. Maybe after some time, maybe a year, 2 years, you can, when the things get crystallized much more, or maybe 3 years, then you can make a fresh will and re-register it. Because registration doesn't cost much. This would mean you are actually updating with further inputs, whether you are removing some items as you may have sold, or fresh additional assets are included as you have bought. Unless there are major changes, you can do it after a small gap of time. Both changes and modifications are synonymous. Changes means some changes you make. Modification, you just modify the terms. Okay. Revocation would mean cancellation, complete removal of the will. Why one has to revoke it? It is either there is a change in the beneficiary or change in the mind of the testator. Sometimes this is voluntary, sometimes involuntary due to operation of law. Mostly involuntary when due to a marriage. When a testator, if a lady gets married, the original will with all its modification etc. will stand cancelled or revoked. This is mostly seen in women getting married under the laws of Parsis or Muslims. It depends on the circumstances. Again, it becomes redundant if all the items mentioned in the will does not exist anymore, or the majority does not exist anymore. Then what is the use of the will? The will becomes inoperative, and in such case you must revoke the will. Sometimes there are lots of changes, then the testator may revoke the original will and replace it with a new one. Here you need to mention that the old will and say that this new will replace the earlier one dated so and so, or you can say that this new will supersedes the earlier one dated so and so. If the original will is registered, you need to register the new will, or if you are revoking it, you need to put it in writing and make a cancellation deed and register the cancellation deed also. And for this you also need to have 2 witnesses. If you are replacing with a new will, then you need to mention the old will details, and then the question of cancellation of the old will doesn't arise because you have made a new will and that replaces the old will. But if you are completely cancelling it and not making a fresh one, then this cancellation deed will have to be done. If a will is not registered, you can simply destroy it, tear it with all its copies. For executing the original will is required, and if the original will itself is destroyed, it cannot be probated. But there are enough of people, smart people, who can misuse, and they can file a petition stating original will is misplaced, and they may have a copy and they will file the copy. So it is in this context it is advisable that you take the original will and the copies, and all should be destroyed, torn off or whatever. Probate process. Let us now move on to the important process, probating. First of all, you can apply for probating only after 7 days after the death of the testator. We had discussed this earlier, and also we had discussed what probate means. To recall, probate is a legal procedure to be done in a court for executing a will. This has to be done through court proceedings. It is certified under the seal of the competent jurisdiction with a grant of administration to the estate of testator. Grant of administration to the estate of testator would mean that the court gives the right to the executor to administer the estate of the testator. You should know it is compulsory or mandatory to get any will probated under Section 57 of the Indian Succession Act 1956 in NCR, Greater Mumbai, erstwhile Madras jurisdiction, and Greater Kolkata, and the 3 states of Assam, Bihar and Orissa. In these places, without probating, the will has no value in these places, and you cannot change ownership of the immovable property. It is mandatory. So what it means? You have to make an application to the High Court, Testamentary Division, where this is done, along with affidavit and other documents by all the heirs. If the application is correct, it may be accepted, and then the process of probating starts. That would require all concerned to visit the court, satisfy the court. The court would see that all the personal law is complied with, and since different laws apply for different communities, and make necessary notification, call people, verify claims, etc. I repeat, you need to remember probating is mandatory for the will to be effective in the 7 places that I mentioned, and probates are granted by the High Court. The various laws involved are Hindu Succession Act, which covers Hindus when there is no will, plus Jains, Sikhs and Buddhists. Muslims laws are uncodified based on Sharia, which are further divided into rules separately for Sunnis, Shias, Bohris, Kachis, Memons. Now, when Hindus, Jains, Sikhs, Buddhists have will, then they are not covered by Hindu Succession Act, but by Indian Succession Act. So basically, if there is no will, Hindu Succession Act comes in, and if there is a will, Indian Succession Act comes in. This Indian Succession Act also covers Christians in Chapter 2, Part 5, and Parsis in Chapter 3, Part 5. Now let us look at the executor. In the will, you have already named an executor who represents you after your death, right? Now what happens if the executor predeceases you, or at the last moment does not want to be an executor, or refuses to be an executor for whatever reasons? Then what do? You can make an application to the High Court asking them to nominate an administrator. In fact, you can identify the person concerned, or the court will do it. The letter of administration is to be prepared, and with copies of all documents and reasons for executor to the executor's refusal to act as executor, and submit the same to the High Court. See, understand, administrator is like a custodian or trustee. Once he is nominated and the court approves it, he acts as a custodian and executes the will in the format given. The situation is true when the testator passes away interstate, that is without leaving a will. In this case, one can apply for appointment of an administrator, probating here, through letters of administration after obtaining the legal heir and succession certificate. And here there are a lot of other formalities. You need to give a huge amount of surety, equivalent amount of the assets value as surety. Somebody will stand when there is bond. There are a lot of issues over here, but there is an alternative. You can also name 2 executors, that is, stating if the first named executor predeceases the testator, the second one will be treated as executor. So this option is given. Other things to know are, if any sibling spouse does not want part of his share, then he or she must confirm it through a no objection in a stamp paper. And if she is overseas, she can give a letter to the Indian consulate there. Documents that are generally required are, it is will, death certificate, KYC papers, any proof of the property concerned, list of legal heirs, amongst others. Time period. It would normally take anywhere between 5 to 12 months to get a probate, depending on complexity. Nowadays it's taking a little more time. Entire probate and estate administration process post getting probate and distributing could take another 9-12 months in normal circumstances. Now it is taking much more time. After you get probate, legally you can transfer it in your name. If cooperative housing society, then change it in your name. If bungalow or independent house, then change the property card in city survey office and Satbara extract in Talati office. Cooperative housing societies will take 1 to 2 months max, while property card and Satbara extracts, they take a year. If any will or property card lies outside the civil jurisdiction or the high courts of Mumbai or Madras or erstwhile Bengal, Bihar, Orissa, Assam and NCR of Delhi, you don't need to take any probate or any letter of administration. So these places, outside these 7 places, your will is sufficient. You don't need to probate the will. Basically, you can probate can be avoided only in case of immovable property in these places, but in other places no probate is required. See, probate in these 7 places are required for immovable property. Balance others are you can manage with succession certificates and legal year, etc. This we will deal it in much more detail later on. Okay, now movable property, that's it. Okay, duties of executor. There is a big list of work to be done for executor. His role is very important, hence his choice by testator, as mentioned earlier, should be well thought of. The wish list of work of executor could be anything, though many would be done by family itself in India. Some of the wish list, including those to be done by family, are like informing the relatives, getting death certificate, etc. But in overseas, all these functions are also done by the executor. So let's look at the general functions in the Indian context. The executor will take charge of the properties, he will take charge of the estate, bank accounts, other wealth. He will list out all the inventories, identify and list all assets, whether movable or immovable, where required. He will appoint the services of a specialist like CA for accounts, lawyers for court pending cases and for dispute redressal mechanism, an architect, a valuer or a surveyor, and very rare cases an actuary for evaluating the values of different assets. He will then meet up with all the trusts, estates, committees, banks, tax, club membership and others for closing. He will take the will to probate, because section 57 of the Indian Act, Succession Act 1956 stipulates probating the will is compulsory. This should be done by a competent court, High Court in our case. On the basis of such probate, property should be transferred to avoid any dispute later on. He will intimate all like LICs, Provident Fund, pension and various trading, DMAT, mutual fund, shares, you may have post office, what else is there, investment bonds, mutual funds, banks, etc., etc. The list is long. He'll have to inform everybody. Then he'll also obtain the balance funds from all these places, close account and change ownership of the movable assets like car. One small thing at this juncture I would like to mention is, normally BMC would give 1 copy of your death certificate free, but I suggest every time whenever situation comes, you apply for 10 copies or 15 copies at a time, because so many copies will be required which I have seen at different places. So ideally you must right away apply for 10 to 15 copies. Friends, with this we have covered the main part of the will till probating, while there is still more to understand, which will be taken up in the next series, that is my series number 6. If you have not been able to understand any portion till now, feel free to write to me and I will try and give you a reply as soon as I can. I am sure by this time you will have understood the importance of making a will and how to go about it. You would have been better educated now. Okay, my mail ID is given below. Next video we will complete discussion on will. That is only the one instrument of inheritance instrument. There are other inheritance instruments like succession laws, legal heir, nomination, gifting, relinquishment, etc., which we will see from video series number 7 onwards. If you have liked this video, please go ahead and ring the bell, click the subscribe button, and don't forget to leave a comment. Thank you for watching, and meet you in the next series.